Hi. Good afternoon to one and all. We will be starting with the Designs Act 2000. It is from the CS Executive New Syllabus point of view. It's your Economic, Commercial, Intellectual Property Law, the Part B part. So we will be starting and completing this lesson in one go. So all I need you to do is switch off your mobile phones, keep it aside, get your modules out. I will be covering entirely from the module. Okay. So before I start, I need a confirmation if I'm audible and visible to you. So we will start. Okay. So just let me know in the chat box whether I'm audible and visible. I have prepared this entire notes. It takes tremendous amount of effort and time that goes into preparing these notes, these PPT slides, etc. But for you, it's going to get over in less than 1 hour. Okay, and this entire chapter will get over for you. Okay, so all the hard work is done by me. The easy part is now left. Okay, great. Thank you, Yeshu and Sona. Great. So let's begin with the chapter. Okay. Sarvari, great. So let's start. So we will begin with the chapter. Just before I start, let me just make my chroma key a little higher. Yeah. Okay, so let's begin. Oopsie. Okay, and just before I start, because once I start, then I go continuously till I complete the entire chapter. So before I start, you all can join the WhatsApp and the Telegram groups given in the link of the description and pinned in the chat box as well. Okay, we are completing almost every day one chapter or one part of a chapter. So you have to be with me till the very end. You will complete a substantial important part of your syllabus. Okay, so let's begin. Hi, so we'll be starting with the Designs Act 2000. The Designs Act was among the latest acts that was passed in the intellectual property laws. Now, the Designed Acts in India comes under the Department of Promotion and Industry and Internal Trade, the Ministry of Commerce, and under the office, under that, below the department is an office of the Controller of Patents, Designs and Trademarks. So you have to remember this is where the entire authority comes in. Just a second. Okay. Just a sec, let me get my pen. Just a sec. Okay, I'm just need to set it up. Just 2 minutes. I'll get my pen out. Give me 2 minutes. I just need to get my pen ready. Okay. I'll just fix it up. 2 minutes. Till then, you can read through the introduction part of the chapter. Let's see if you understand it or no. Give me 2 minutes. I'll get my pen and I'll be sorted. Okay, so now we'll begin with the chapter. Keep your modules ready and we'll be sorted. Thank you. Hi, so we'll be starting with the chapter called as Designs Act 2000. Now, Designs Act is one of the latest intellectual property laws that have been recognized in India. It comes under the Department of Promotion of Industry and Internal Trade, the Office of the Controller of Patents, Designs and Trademarks. So all the application is made to this department and this office. Now, what is exactly the Designs Act? Now, when we see there are, as a purchaser, if you go as a consumer, when you have to buy goods, you look at the not only the quality, but you also look at the visual aspects, the graphical aspects, the representation of the object before buying it. Something which has a beautiful design, there is more chances that the customer will pick that up. Let's say you go to buy a mobile phone and you have to choose between two mobile phones having the same specification and the same price. You would choose the one which is more appealing to the eye. So when a particular company is manufacturing a product, they try to keep the design of the product, the shape of the product extremely nice and appealing. Now when they create beautiful designs, the designers create beautiful designs. So law says that if someone tries to copy these designs, he should not be allowed and compensation should be given to the owner. To get this designs rights in your name, you need to be registered under the Designs Act 2000. So the Designs Act 2000 is a legal framework that regulates the protection and registration of industrial designs. It provides exclusive rights to the creators over the visual aspects of articles and also preventing it from replications. So many times we see counterfeit goods, someone trying to copy the entire design, the entire layout of the product. So this can be prevented if a person is registered under the Act. Sometimes purchases of an article is influenced not only by their practical efficiency but also by their appearances. Designs is one of the categories of IPR which focuses on the aesthetic feature of an article. The aesthetic, the beautification of that article. Relevant to the shape could be nice, the configuration, the way of placing things, the surface patterns, etc. Okay. Now Designs Act is an element of industrial design. So designs is an intellectual property as well. So if a designer is there, okay, and he has designed something very beautiful, the product shape, so he can come and get himself registered. So let's take an example. If I ask you from the two images or the two products, which one do you like? The one in the left or one in the right? Now when we go to see the jewelry business, everyone, there could be many producers, manufacturers, or you could say sellers selling the same amount of carat or the same amount of value, but the design is what is different. If I would ask you, maybe someone would say they like the first one and someone would say they like the second one. Now this second one, you liked it because of its design. This design should not be copied, and therefore the designers get themselves register their products and their shapes and the color combinations, the patterns registered under this Act. Further, if I ask you, just even the your particular products or articles, also from the shape of the article you can identify the company as well. So obviously it's your intellectual property, because from the shape, even if I wouldn't have told you which logo it is, the company name is not written, but just by the shape of the product you will be able to identify that it is a Ferrari. Similarly, just by even the looking at the wheels or looking of the shape of the headlights, you can immediately figure out which car manufacturer it is. So what do these manufacturers do? They get their design of the product registered. Then one you see of my favorite cars are also here, the Maserati, the Bentley, and you have your Lamborghini. Even the Rolls-Royce have separate shapes. So the shape plays a very important role in purchase decision. To make this shape, there is an immense amount of creative exercise that is involved, and therefore this law intends to protect the creator. The entire act or the Designs Act, Industrial Designs Act, is in two main parts. One is the Designs Act 2000 and the other one is Designs Rule 2001. It came into force on 11th May 2011, repealing the earlier act which was of 1911. So the Designs Act came in and the rules came in 2011. They came into force on 11th May 2011. Now, what do you think is the object of the act? Simple logic. The object of the act is to protect original and new designs. The object is to protect new designs. So someone who's thought a lot and then made a beautiful article, we need to protect them. Second, we also have to give that right to the creator, that you can apply it wherever you want, you can sell it to whoever you want, you can license it to whoever you want. So you have a right to apply that shape on that particular article. You have a right to process and manufacture that particular thing, and you can file cases if someone makes an unauthorized use. When designers are getting protected and they can monopolize, they can commercialize their intellectual process of creating a design, this would encourage design creativity. It would provide protection to the designs, protect the intellectual property, and also reward the innovator. Now, we will look at the evolution of the Designs Act. Okay, how did the Designs Act come into force and which are the designs law today? So first, it all started, the evolution of the Industrial Designs Act came in 1859. In 1859, the Governor General of India passed an act granting privileges to the inventors, offering limited protection to their designs. So in 1859, we have recognized the work of designers and protection was given. In 1872, the Patent and the Designs Act was introduced, okay, which again was an advancement to the earlier law. Then came 1888, the Inventions and Designs Act 1888. It gave separate provision for inventions and designs, because you go to see so many designs of laptops, of any kind of furniture. Let's say if the furniture that you are, when you go to, let's say home shopping, you look at the particular thing, you look at the TV, you look at their lights also are now getting different kinds of designs. Even the fan, if you look up to your ceiling, you will see that the fan is of different shapes. The manufacturers get themselves registered. In 1911, another act was passed, that is the Patent and Designs Act. Then came 1970, which repealed all the previous laws, okay, and covered a separate act for designs. Then in the year 2000, now when we are concerned with, once you know the years, the legislative history, which all acts were there before, what is important is today, and this is what we will be seeing. And how did it come into force? So Article 25 of the WTO TRIPS agreement. So in the TRIPS agreement, trade related aspects of intellectual property law obliges members to provide protection of independently created designs that are new and original. Obviously designs which are new and original will only get protected, but we wanted an act to align as per the TRIPS agreement. So India repealed its previous law, which was of 1911, and enacted the Designs Act 2000, which was in line with the TRIPS agreement. So I hope these three keywords are set. Article 25 of the TRIPS agreement, pursuant to which 1911 law was repealed and Design Act 2000 came into force. Now when we look at designs, almost every aspect of designs is there in almost every article. So even if you go to see today, the shape of these software drinks, these soft drinks, you will see that a Coca-Cola bottle, even if you remove the cover, you will be able to identify that this is of Coca-Cola. You will be able to identify this is of Fanta. And let's say, for example, hypothetically, I would have removed the label. I would have given this bottle to you. Would you be able to identify that it's a bottle of Sprite? Yes or no? Obviously, yes, it has a very separate, it's green in color, it has those dotted things, it has a separate shape. So this, the manufacturer would want to get it registered under the Designs Act, because there are a lot of copycats in the market. Now, a small case law was given. Okay, let's see. In the case of Bharat Gas Tube Limited versus Gopal Grass Works Limited, in this case the Supreme Court made the following observation. So Supreme Court made few observations. We are going to see those, and we try to cover what was the objectives of the law that was there for Designs Act. So similar things, we are still into the introductory part of Designs Act. When it did come, what was the previous laws, what is the Designs Act, etc. So we are just reading that. The Designs Act 1911 was enacted by the British government. Obviously 1911, then it would be by the British government only. However, in responses to the advancement in science and technology and increased registrations in designs, the Parliament took to repeal the Act and pass the Designs Act 2000. Now what is the objectives? Again they will repeat: efficient protection. The objective was to provide efficient protection to all kinds of designs that were there. Promotion of designs activity. Now the Act aimed to promote designs activity, so not only to give protection, but also to ensure that creativity, design activity is encouraged. Next, if you go to see balancing interests. Now obviously balancing interest means what? The government will try to give the creator some kind of benefit, so that even the economy is benefited and the people around are also benefited. Because when these creators, in order to get registered, they have to pay the filing fees, etc. They will license it, or they will create economic activity. Okay, so this will be there, and at the same time, a design registered under the Act, does it get protection lifetime? What do you think? Do you think a design registered is protected for lifetime? Yes or no? So the answer is no, it is not protected for lifetime. You get a protection for 10 years, which can be extended for 5 years, and that is it. It will then fall into public domain. For example, that means only a design can maximum be allowed to be registered and protected for 15 years, 10 plus 5. We will see when we do that. So the government is trying to play a balancing act of taking revenue, of encouraging designs, at the same time putting this design into public domain after a few number of years. Now, case of Escort Construction Equipment versus Action Construction Limited. They again said what is the primary object of the Act. The primary objective of the act is to protect the shape. You can mark this, protect the shape. And again, negatively, the second thing, they also say not this. The object of the act is to protect this and not this. Means what? Not the function or the functional shape of the design. Mark it is important, not the function or the functional shape of the design. Means what? See, the entire purpose of the act is to protect designs which are appealing to the eye, which have a certain characteristics, which can identify the goods from other products. Okay, but not the functional part. So let's take an example. We have so many designers. When I talk of designers, can you tell me which designers can you think of? Can you tell me the famous designers in India? Okay, let's talk about textile articles. Textile articles or clothes. Okay, Manish Malhotra, he has beautiful dresses. Okay, so let's say if he has made a dress. Okay, he has made a dress. Okay, this is a design one. Okay, now this design, the designers all over India, they know that their designs, who are famous, okay, celebrity designers, they know that it gets copied really quickly. So they, before they publish it, they get it themselves registered. Now what are we saying? The shape will get registered, the shape. So this beautiful shape which has been made by a designer will be registered, but not the functional part, not the functional part. For example, if I realize that let me just put a belt, okay, for this dress I want to put a belt, which is not really creatively, but it is for the functioning part. So therefore this part cannot be registered, just if you are trying to enhance a function without changing a major amount of shape. So that is what they're saying. The functional, operational, running part we don't care. We care of what is visually there. Or let's say someone has put a zip has been put here. So that is a functional thing, not with respect intended to make a design. Okay. So collectively it will be decided whether it should be registered or no. Limitations of the Designs Act, again I told you very simple, that they do not encompass methods. It only the shape, okay, not the method, not the principles, not the function. That all we don't care. Okay, if I tell that this is a very beautiful dress, it can be in water also, it can go in extreme heat also, it can work. So that's the functional part. That is not what we are registering. We are registering the shape, the visual shape of the product. Now when we say that designs can be registered, so let's understand what is the meaning of the term design. Very, very important section. Okay, you need to know what do you mean by the term design. Now if I would ask you, because it's a very important definition as well, what do you mean by the term design? Designs will be registered. So what is a design? So first thing, if I look, a design might be a shape. It could be a pattern. Okay, few patterns which are there. For example, if I tell you the Louis Vuitton bags or the Gucci bags, okay, when you see those, just by the pattern of their bags, I'm not talking of a logo, I'm talking of the entire pattern of a Gucci bag, you can visualize it. Okay, it will have some tint of green, it would be, these checkered things are there, the pattern. Or we are talking of ornament, the composition of lines, how the lines are placed, the color codes that has been used. Okay, if you see Dairy Milk has also registered the design of Dairy Milk. You can identify the color codes which have been used, which are there. which are applied to an article. Configuration is a combination, whatever is there, which is applied to a article, which might be either two-dimensional or three-dimensional or in both forms. So something which might be two-dimensional or three-dimensional, okay, it could be more in a something which is more than just one-sided. Could be more, 2, 3 sides, 4 sides can also be there in both by any industrial process. So for example, if I'm talking of protein shakes. Now this is very weird example, but I'm just saying a protein shake. Now when you see these protein shake, these bottles, they have these different kind of gym bottles that are there, or even your Tupperware boxes, bottles. These are three-dimensional images which will be manufactured and sold. Now they are saying this shape might be either manually you have made. For example, I have stitched a carpet. Kashmiri carpets are very famous, so they must have stitched and make that particular thing. Zari work is there. Then or mechanical. Okay, so mechanical equipments can be there. For example, a mechanical part could be an industrial product which looks in a certain way, or chemicals, separate, combined, whatever you call it, which is connected with an article and is appealing and appeals to the eye. Sometimes just by looking you like it. Okay, you say I like this design, I can connect with it, so you will purchase. But does not include. Now again I told you, in Designs Act, even in the Supreme Court judgment we saw two things. It will register shapes which are applied on a product, whether it two-dimensional, three-dimensional, which is appealing to the eye. But they do not do anything related to functions. Functioning cannot be registered under the Designs Act, because Design Act is only about shape. But does not include a mechanical device, a mere mechanical device, the shape, the principle, anything, the working, that all is not covered. Mechanical devices by itself is not there unless it has a shape and the above things are there. So mere means what? Only that it is a mechanical part cannot be registered here. Next, but does not include a trademark. Very important. Obviously we are talking of designs. Now trademark is a different thing and a design is very different. So let's take an example. Even if I would have not told you which company or manufacturer this is, just by looking at the shape of the watch, okay, you would have been able to identify that this is a Rolex watch. Okay, now look at this shape that I'm talking about. I'm talking of the shape, I'm talking of the patterns, I'm talking of the color codes on this particular watch. So Rolex would have registered itself first in the Designs Act, and if anyone tries to make a counterfeit product or makes a deceptively similar design, they can sue. Now the question is, the shape is there and the logo is applied here. So can I say in Designs Act we are registering the shape, pattern, configuration of the product and not the trademark itself. This is the trademark of Rolex. The trademark is, as it is registered on the Trademark Act, it is applied on the product, but in Designs Act we are covering the shape of the product, including the color codes, etc. Like for Cadbury also, which I told you. When I say article means what? Any article which gets manufactured, okay, which will be either partly artificial, partly natural, that is also fine. For example, if I talk of products which might be natural and artificial, that is also allowed. Okay, so we can talk of tomato ketchup. Okay, if I see the Kisan jam, or if I see tomato ketchup. Okay, so what happens? It might be naturally sourced, then later it gets manufactured and then sold. So that is also covered, and includes any part of an article capable of being sold separately. So even part of the this which can be sold separately will be covered. Okay, so very interesting. So let me show you another thing. This is very much out of the box, but still, if you see design of your calculators, etc. Now this is the mic that I'm talking about. For example, I'm using this mic. Okay, now this mic has different parts. Okay, so I can take this mic, it has a separate shape, I can put it and sell it. So in the product itself, it's a very beautiful design. If you go to see, okay, you have the transmitter, the receiver, everything. So the Rode mic is there. Now they, just by the shape you will be able to identify. Now though I have bought the entire set, it is capable of being, I can sell loosely also one particular mic because it's sold in the market. So even that is covered. Or you see your Apple earpod, okay, AirPods. So you will see that they can be sold separately as compared to the phone as well. So even that is registered. Next, coming to copyright. Just normally they are saying section 2C means a copyright. Now very important. Let's say if a design is registered under your name, you will be happy or sad? Obviously you will be extremely happy if a design has been registered. It will be said for the purpose of words that you have a copyright in the design. See, what words are they using here for the purpose under this act? Once it gets registered, we will say now the owner has a copyright under the act, exclusive right to apply this design to any article he wants. Now coming to artistic work. Now when I talk of artistic work, it's very different from designs. Let's understand. Now artistic work which is given under the Copyrights Act. Now copyright is concerned with literary work. They have given you the categories in which copyright can be done. For example, writings. My book is there, it's a writing. Okay, that would be copyrighted. Your novel, your scripts, songs, all of that is copyrighted. Artistic work could mean a painting, a sculpture, or drawing. Okay, MF Hussain drawings which are there, or we have very good painters when they are there, or any work of architecture, interior designs, any other work of artistic craftsmanship. So this is when they say the word artistic work, we are talking of copyrights. Now obviously protection in some cases can be given in both, that is architectural designs which are there. For example, the Burj Khalifa. When we see the Burj Khalifa, you can identify that without even knowing the name, you will be able to say which structure it is. So designs which involve artistic or interior designings also, they get themselves protected under this act and the other IPR laws. Now coming to what is the difference between a design and a trademark. I had done it earlier, but I will explain it again. Designs and trademark. A trademark is a mark which is applied on all products. All different products I can apply. For example, the BMW logo will be applied on different products. Apple logo is applied on different products. It will be there on the Apple phone, Apple watch, your Apple computers. Separately it will be done. So it is applied on goods to distinguish one goods from the other. Whereas in designs, we are talking of that product only and its shape. So the shape of an iPod, which was there earlier, okay, is the shape that we are talking about. On that shape, trademark can also be put. So in designs, you can register the shape of the product, okay, and trademark will be the logo of the product. it covers the physical appearances, protects any new and innovative design. So when I see here, okay, so these are all premium pens that I'm talking about. So in the premium pen, when we see the Mont Blanc or these other pens, this might be the logo, okay, this might be the logo or the trademark. But in Designs Act, are we registering trademark? We saw the definition of designs itself, it does not include a trademark. Then what are we registering here? We are registering the patterns, these color combinations, these different elements which are there. This entire shape as a whole will be registered under the Designs Act. Clear? Copying of a design cannot be said that you are copying a trademark. If I copy the design of your product, you cannot say that I have copied your trademark. It's different. Product is different and trademark is, design is different and trademark is different. That is what we are saying. Now, if we go to see another example, very, very simple. In this, can you tell me where is the logo? Where is the logo? Okay, so obviously this is the logo. The Gucci bag is the logo. But in Designs Act, what are we going to register? We are going to register this entire pattern. Just by seeing the entire bag, you can make out that it's a Gucci bag, and because of that, people are now using the same pattern on shoes, etc., and counterfeiting and selling. So this pattern is a design which took lot of effort, creative effort to build. Okay, color combination for people to identify, to make it extremely different. So the design will be registered. So in order, which kind of designs will be registered? So this is very important. Proprietor of designs. Introduction. So they say that it outlines, section 2J outlines, states who is considered the proprietor of a new or original design. So let's see. First, someone, now very interestingly, let me explain. When we see all these particular designers, fashion designers, celebrity designers, they have especially when these celebrity marriages are there, they want to get their design registered because they know it will immediately get copied by the entire public. Okay, and then they can prevent it and keep it exclusive. Now the question is when a design will be registered. So in 3 interesting cases they have given that, one, if the person has created himself, if I have only developed it, it will come in my name and there is nothing else. I have made this design, so it will be mine. Second, owner, second category who can also become an owner. You think Manish Malhotra would have sat and stitched this dress? No, he must have hired someone to make this. Or let's take a company. A company must have made a computer design through its engineer. So who will be the owner? So obviously if we have a company, he has employed a designer and have an agreement, so the company will be the owner. So let's see which are the 3 categories which they are covering of who is the real owner in different cases. When the author of a design, the originator of a design, for consideration executes work for someone else, means the person for whom the design is to be executed. So then it will mean for whom the design is executed is the owner. So let's take an example. If a graphic designer is hired by a company to create a unique logo and they are paid for their work, the company becomes the proprietor of the design. So what is happening is, I have hired a author, a creator for consideration, and he executes the work for me. So in such a case, such person, that is me, I will be the owner of the product. I have paid him and I have told him to make. Just like I told you, employee doesn't become the owner, the company becomes the owner. Next, where someone must have made and then later I didn't have a prior agreement, but I liked your design, I'm ready to pay and buy it from you. So where you acquire the design by paying exclusively or in part the person by whom the right is so acquired. So first is I paid you to make it. Second is you have made and I have bought it. So for a clothing brand purchases the exclusive rights to a specific textile pattern, they become the proprietor of that design. Okay, so there must be a textile pattern someone must have developed, and I say that I am buying this, I will apply it on my products. In other cases, means the author of the design. Means in all other cases, the creator of the designer, and when there is nothing else involved, he will be the owner. Now prohibition, very very simple. Section number 4. When we will prohibit, extremely simple, logical, it's a creative exercise. So if it is not new and original, it will be rejected. If it is already disclosed or published anywhere, it will not be registered because it's already known, you have copied. And third, it is not significantly distinguishable from a known design. If I say that it's very similar, there is nothing new from what is already in the market, so it will not be registered. And comprises or contains some scandalous or obscene things, such marks shall not be, such designs will not be registered. So section 4 important. Either it is obscene, either it is already publicly known, okay, it is not new, and lastly it is not distinguishable too much from other designs. Very same with other designs. Now let's see one case law. Okay, now we are seeing a case law of Brutto Auto Industries versus Shri Raj Chawla. Facts. The Honorable Court addressed the interpretation of the new and original concerning in India. The primary points for consideration were. So very simple. They can ask you that if I have to say something is new and original, how will you prove it? What are the guidelines? What are the factors? So I will say if it is new, then obviously it must not be previously public known. Then we can say it is new. Okay. Second, originality. That means if you are coming to register, I should know that you have created the design. So this I will see to register that yes, it is a new and in your name. Novelty determination. Then we will have to see that how much of variation, how much of pattern, how much of newness has been put in. Determining the novelty, because it might be new, not known, but how much of creative design, creative element is there to really protect it. So we will have to actually look at the visual impression of it. Next is partial newness. Now the question is, partial newness means what? When the entire design need not be new, the part designed as a new must be significant and capable of providing design with a distinct identity. So again they are saying if it is partially new but it is something different, significantly different, then we will register it. Distinct from trade variants. So again we say from what the other competitors in the market, it should be different. The court's responsibility was to ensure that the designs considered for registration are distinct from its common trade variants. Conclusion. The case established that for design registrations in India, the design must exhibit substantial newness. Means it should be new, not only new but substantial newness, and originality. Originality means it should come from the creator, compared to its trade variations, compared to its counterparts which are there in the market. Okay, now let's see application for registration of designs. Section number 5. Now let's say there are a lot of creative people in India, okay, in the world actually. They can draw beautiful designs. Now let's say if you are one of them, you can really design something really nice. It could be a product, it could be for engineers they are there, it could be for interior designing, it could be for clothes, it could just be for any product that you have created. Okay, mobile manufacturing thing you have created. Now once the design is made, how do you get it registered? So the very simple thing is you will make an application to the controller of patents, trademark, design. We saw in the start of the chapter. We saw the department also, Department of Industrial Promotion and Trade, and within that we have the office of the controller's office. So application will be made to the controller claiming that it is a new design and it is not previously known and it is not contrary, please register the mark. It should be filed in the prescribed form with the prescribed fee. A design may be registered in not more than one class. So again, when we are registering the mark also, we will have to identify that which class of goods that is fall into. Okay. For example, a mobile phone which is there, so you will know that in the categories of mobile phones. A watch is there, you know it will be in the category of watches. But there could be some products which are in between. Let's say we have a laptop and we have an iPad, or we have a notebook laptops. So we don't know exactly that which category will it fall in. Will it fall in laptop? Will it fall in these small desktops? So again, the class category of product in which it will fall will be determined by the controller. Next, the controller may, if he thinks fit, refuse to register the design. Okay, any person aggrieved can appeal in the High Court. 3 months time is there. Decision has been given by the controller. Within 3 months you have to run to the High Court. If the applicant, because of his default, has neglected his part or he has not responded to the controller, we will treat the application as abandoned. Means what? Applicant after making an application didn't care only. So again we will say that we feel that you have abandoned your entire rights. So it will be cancelled. A registration a design when registered shall be registered from the date of application of the registration. So now remember, whenever we do IPR laws, always the protection starts from the date of application, not of the date of grant. Can anyone tell me why? See, this is the date of application and this is the date of grant. Can you tell me that protection will be given from which date? So obviously it will be from the date of application and not date of grant. Why? I'll tell you very simple. Moment you make an application, it gets published. So then everyone will start using. So therefore we say that moment you make an application, you are making it into public. So therefore protection should be given from that day once it is granted. Now coming to key requirements for design registration under the Act. So we saw for registration we will say it should be new, it should be original, article features. Now again what we are seeing is any article that is there, we will have to see the shape, configuration, pattern, ornamentation, the placement, jewelry placement, all of that will be seen. For ring, now ring also there are so many different kinds of rings in the market. Okay, so you will have to see the article features, industrial applicability. You will see if you can put it into manufacturing and selling it. Okay, industrial process. Visual appeal. Visual appeal means it should be appealing to the eye. Exclusion of mechanical devices. I told you which is mere mechanical devices will not be allowed. What means? Functional aspect is not what we care about. The visual aspect is what we care about. So moment you have come to register something which is mere only mechanical part with no aesthetic value, we will tell we can't register it. Simple. The design registration is for visual part and not how they function or operate. Functioning part, take a patent and or do it. Go a process patent. Not there. Here it is a visual aspects. Exclusion of trademarks. So obviously we are saying that trademark is different and your this mark is design is different. Now coming to registration to be in respect of particular article. Section number 6. Now what are they talking about? Let's see. Registration to be in respect of a particular article. Now when we register, now it's very interesting aspect which I will share with you. When you register a design, is it for a particular article or multiple articles? Think and tell me, because when I read the provision then I will check your knowledge. So the design, I just want you to say, is the design registered for one article or multiple articles? So the answer is multiple articles. You must have said particular article, right? But see, I'll explain what it means with the help of an example also. Scope of registration. A design may be registered for any or all the articles comprised within that class. With respect to class or any dispute, the controller's decision is final under which category of goods it is. So that is also fine. That is not what we are important. Now this is what I'm talking about. Subsequent registration of same design on other class. See, the design, you can get it registered not only for that product but for other products as well. So let's see. Now let's say you have got your this crockery that is there, kitchenware articles. Okay. Now you see they all have the same pattern or the design. Let's say I am the designer. I have got this design in my name. So the design is there. Now this design I had done it for plates. For the plates I had got myself registered. Now this same design I want to apply on the jar, on the bowls, on these other things as well. Okay, the cups. Now will the design be applicable on others as well? So here they are saying that if you are the owner of the design, if the owner applies to the controller that listen, I want to apply this design on other classes of goods as well. From plates I also want to put on cups, on spoons, on the teapots, everything I want to do. So that can be registered. The controller cannot deny the registration on this ground that there is already the design registered on one category of goods. That means on plates it is registered the design. So just this cannot be a ground for not allowing the design on other thing, provided that the owner is only coming who had the first thing. It is new and it is original and it is not published. So let's read now. It's a very simple thing. I have explained it to you. Let's read. Where a design has been registered in respect of any article comprised in the class of article, the application of the proprietor to register in respect of some other article shall not be refused, nor registration be, or the registration thereof be invalidated. Okay, so then when you go to read you find it confusing, but let me tell you. What are they saying? That the proprietor of the design, first the owner of the design, who has on one article, wants to apply that design on other articles. So then this cannot be refused to me. It's my right. I will get to apply that design anywhere else also. Nor can one say that listen, you, the earlier registration which was there on plates, you deactivate it. So that also will not be done. Provided it is a new design. Okay, it will not be. Now again, very interestingly they have put it across that it cannot be denied by the controller that listen, this design is already, it's not new, it is already known since it was priorly published and put on the plates. I will say listen, both the grounds that it is not new, I was only the creator, and priorly published, I only got it published. So these two grounds cannot be a ground to invalidate my right to apply the design on other classes of goods. So let's see what they have said. For example, a designer created a floral pattern and registered it for the use of ceramic plates. Now the designer can apply to register the floral pattern to some other kitchenware items also, such as cups, bowls, tea trays, without being refused solely because the pattern was previously registered for plates. Simple. Now coming to ownership change during the application. Now it's pretty interesting again. Okay, I have made an application. So let's see, there is a case of application. So there is a applicant. Okay, there is an applicant. He is applied for registering of designs to the controller. Applicant has applied to the controller for registration of designs. Now this is pending. During this time, it is possible that he might have sold off his rights. Okay, there would be another person to whom he must have sold. So in such case, the controller can amend the application and say that this other person will be put as the applicant, new applicant. Okay, let's name him Mr. A. So Mr. A will now be the new applicant. Or second scenario they've covered, by a court case, we came to know that, listen, you're not the sole owner, you're a joint owner. So we will again switch. Or the court said that remove this guy's name and put his name. So that also can be done. Let's read. Ownership change during the pendency of the application. So provides that allows the design registration to continue even if an applicant of the design is similar to an existing registered design with minor changes, provided the applicant becomes the owner of the existing registered design during the registration process. Wait, what? See, someone becomes the owner of the existing registered design during the application process. So let's see. If it is similar and to some other thing and I have bought out the rights, we'll read it first. Where any person makes an application. So any person makes an application for registration of a design in respect of any article which has been previously registered by another person. So I have made an application to register a design which has been previously registered in the name of another person, or design in which the application relates to consist of designs previously registered in respect of this with the same or modification or variation. So there is one guy who is coming using the same or similar design and saying that register in my name. Should the controller allow or not allow? The Apple design of the phone, I want to apply it. So obviously it will not allow to register the design of someone else in your name. But this is what they are saying. But they will allow if during the pendency you become the owner. This is what they're saying. If at any time while the application is pending, the applicant becomes a registered design of that previously registered mark, okay, then the foregoing provisions shall apply. All those previous Designs Act provisions will apply as if he is only, the applicant is only the registered proprietor of the design. Okay, so there is an innovative article. I say that the article is in register this article in my name, and during the pendency of the case or before the application procedure, I have applied that I have bought out the rights, so it will be allowed. Simple point that is there. Now Now see, these are all in laptops, so many spare parts are there, so many designing parts. All of these are designs which can be registered. Okay, let's see the other thing. Publication of registered designs. Very simple. So section 7 states that the controller, as soon as possible, one moment the registration is done, will cause a publication in the official gazette and the journals. Very simple. We always do that. Moment it is registered, we publicize it. Now see, industrial designs which are there, there can be architectural designs which are also there. Now substitution of applicant or joining the claim. So now earlier we saw that someone became the owner and said that after he becomes the owner, he said put this mark in my name. It was in someone else's name, but I have bought out the rights. Now we are seeing of substitution of applicant. So both the cases I had explained, here this will be there, section 8. Section 8 addresses the provisions related to substitution of application and the possibility of joint claims. So I told you that there can be a court case or something like that. So conditions have been given here. The name of the applicant can be substituted or a joint claim can be made for a applied design. So what are they saying? I want to substitute the name of the applicant, or I want my name to be added with the applicant if the following conditions are met. So what are the conditions? Requirements. First is timing. The claim for substitution should be made before it is registered. Obviously before this application is disposed of, you make an thing that please remove him and put my name. Creation of claimant's rights. Now as we saw earlier also, we'll ask how did you get this right? So you will have to say that by way of assignment or an agreement or by operation of law. Operation of law could mean someone passed away and the legal heirs are saying that listen, he had applied, now substituted in my name. Identification of the design. Obviously when you're saying that substitute the application, you have to say that which design are we talking about. So you'll have to give the application number, reference number to correctly pinpoint which design is in your name. Court case rights can also be decided by the court. Now application process. So again, a request for this application will be made in form 2 to the controller, and if he is satisfied that claimant would be entitled to the interest in the design, he may proceed with the application in the name of the claimants or in the name of the claimants and the applicant jointly. So what is happening is, we are seeing that someone is saying that join my name or substitute the name. It could be a court case. After a court case I have won, I will, before it is granted, I can say that listen, he has applied, remove his name, I won the case, put it in my name. In case it has to be in joint thing, then and a court case is also not involved, then cannot be done without consent of the other joint applicants. For example, there are 2 people whose names are coming and a third founder is also coming. So you require consent of everyone. Substitution in case of death, I told you, the survivors. Now this is also very interesting. If 2 people have applied for the design to be in their name, one of them dies, then ideally it will go to the surviving member if the surviving member gets a NOC from the legal heirs. Okay, but consent of the legal heirs should be there. So legal heirs of the deceased could be given money and the rights could be taken or whatever. Then the deceased, the legal representatives can also be a if agreement is not there, then instead of the deceased member, the legal representatives will be the owner. Resolution of dispute. So whenever there is a dispute between anyone, the controller will give directions as he deems fit, and the controller shall not pass any order before he listens to all the parties. Then next is section 9. Section 9 is certificate of registration. So they will grant a certificate of registration to you. So moment all of this is done, we will grant you a certificate of registration. In case of loss of original share certificate, you can apply, you can get copies also. Now this is the effect of registration of a design. So there are two important things: a register will be maintained and effect. Effect means what? First is, moment the design gets registered in your name, now you will have a copyright on the design. You can use and prevent others from using, and a register will be maintained in which your name will be put up. So a register of designs is maintained by the controller, and this will be prima facie evidence. It will be evidence that you are the owner of the particular design. So if in the design, if in the registry your name is mentioned as the owner of the design, then you will be prima facie owner. Now this is one of the most important and interesting thing also. Does a design registered will be available forever? What is the duration of the design? So the answer is very simple. You will get the designs for 10 years. Okay, they call it as copyright in the design will be for 10 years with the owner. And after this, he can extend it before the expiry of 10 years. He can extend it for another 5 years. So extension could be done, and that too application has to be made before the expiry of 10 years. Then it can be extended for 10 years it was there initially, then 5 more years. After 5 years, no protection is given. It will go into public domain and people can use it. Okay. Now they've given microfibers versus Girdhar and company. The Delhi High Court had put some guidelines. So you can just read up the points. I've put down the head points here. What they've said, the broad definition of artistic work. So some guidelines that they have put, the Delhi High Court, that artistic work is broadly defined and not restricted by needs of any artistic quality. When I say you are an artist, will I say what kind of artist, or I'll keep the definition wide because it's a creative field, anything can come in. Next, rights of the holder. The rights granted to the holder of an original artistic work are detailed under Section 43 of the Copyrights Act. So in the Copyrights Act, Section 14, subsection C, the rights of the holders are there of copyrights. And almost all IPR rights are the same. You can use or prevent others from using or licensing it. Exclusive reproduction right, they will have an exclusive right to reproduce the design. Limitation of design protection. Okay, so so design which is there and copyrights operate in two different spheres is what they are saying. Legislative intent, okay, is to provide in copyrights, the legislative intent is to protect literary work. Literary work is writings, songs, artist performances, all of that is there in this. Limitations in copyright protection. So this is one important thing we'll see. Continued protect copyright for original artistic work. Now see this point. Copyright ceases for registered designs under the Copyrights Act. Additionally, designs capable of being registered under the Designs Act but not registered lose copyright protection once applied industrially more than 50 times. See, in copyright protection, see, it's a creative field. Their designs is different, copyrights are different. Copyright is about literary work, writings, etc., paintings, etc. Whereas your Designs Act is something which goes into industrial application, manufacturing, etc. However, there can be overlaps also, which both will also covered. Okay, it depends on case to case basis. Normally they will say that it operates in two different spheres, two different acts, but sometimes it can be overlapping as well. Overlapping protection under Copyrights Act as well as Designs Act. So copyright ceases for registered designs under the Copyrights Act. Additionally, designs capable of being registered under the Designs Act. Let's see, a design which was capable of being registered under Designs Act but not registered lose copyright protection once industrially applied more than 50 times. So up to 50 times they can be copyright protection can be given, but beyond 50 times we will say it's an industrial application, you have to get it registered under Designs Act. So certain designs which could be registered under Designs Act but are not registered, but we will still protect you, because copyright is what, mere on creation you get certain rights. Okay, for example, a book need not be registered. By default only you get protection, but to prove that will take time. So they are saying that a design which is there, which could fall under both Designs and Copyright Act, which you haven't registered it will lose protection after 50 times industrially applied. Then you will not get copyright protection. You will have to apply for under this Designs Act. In your copyrights, we don't intend it to be published and copyrights and sold at a larger scale. Okay, these articles, obviously writings are exclusive to copyright only. Continued copyright in original art, okay, granting longer protection under the Copyrights Act. Interplay between copyrights and designs, I've told you there are different years of protection, etc., which is there. Okay, so this you can read it with the headings. Now we'll go ahead. It's not a section or anything. So now we will read the restoration of lapsed patents. The market is important, so whenever you see a section or and this, it is directly important. Now restoration of lapsed patent, we saw that within 1 year before it ends, 10 years before it ends, you have to get it registered, but so you'll get 5 years extension. But if you don't register it, then it will lapse and everyone can start using it. Okay, and if it lapses, then you can apply for restoration of lapsed designs. Okay, within 1 year from the date it ceased to have effect. So very, very important, you can apply it within 1 year of it ceasing to exist. Very, very important. So if you have not paid the filing fees, you will lose the protection. You can apply for restoration. If it is joint ownership, then with the consent of the controller, one or more joint owners can also apply. You'll have to pay the fees, set of circumstances, give the evidence why you didn't come within the time limit. Okay, you may apply for restoration within 1 year from the date it ceased to have effect. So if it got expired, 10 years got expired now, 1 year grace period has been given within which you can make an application. Beyond that, nothing can be done. Now we are seeing, can the registration of designs be cancelled? Let's see, when can we cancel a design? Obviously, if it must be previously registered, published, not new, not registrable, not a design as per the definition. Simple. Then comes designs to bind the government. Again, very simple, section 20. What does it say? That the Designs Act gives you protection from individuals, but the same protection is also given against government. That means government also cannot come and use your product or design. So effect of registration gives you the same protection from others as well, just from others what rights you have, the same rights you have on against the government also. So if the government has used your article in some of its ads, on some of its products, claim anything, you can also sue as you would sue any individual. That's what is given. When a design is registered under Designs Act, it carries the same effect and rights against the government also as it would give against any other entity. So the government is bound by the rights and protection granted to the registered designer. They cannot disregard a designer. Application of patent provision. Now this is also very simple, that if someone has copied your design, then you will get all the powers which are mentioned in chapter 17 of the Patents Act 1970, which deals with legal procedures, infringement, legal actions. So they have given that in design also, if anything wrong has happened, you will get all the powers which are there in chapter number 17 of Patents Act, which talks about how you can move ahead with infringement. Now we talk of piracy. Extremely important question. What do you mean by piracy? Piracy means copying. How can you copy a design? So either the design is applied, application of the design on any article. So I take an article and apply that design, pattern, etc. Or I create a imitation, a kind of fraudulent or obvious imitation, like a knockout goods or counterfeit goods or deceptively similar goods, which are very similar, a pattern which is very similar. So then I will say that there is a piracy, copying of my design. Second, if there is an import such article for purpose of sale. Let's say there is an import of an article which has my design. For the purpose of sale, I will say this is my design. I'll get it protection. And third, someone puts my design for publication and are selling the design. Okay, so I have made the design. Okay, let's say there's a graphic designer, he has made the design and someone else is using the graphic designing and selling on certain e-sites. That listen, I am the owner, you can use my design. So all this, the registered owner can prevent such unauthorized use, importation or distribution or publication of your design. Now coming to industrial and international exhibitions. Very, very interesting. Now see, what happens is, Government of India has various summits that they have, various exhibitions that they have, expo, if you see expo, which is there in different countries. So here, if a design was presented in this expo, okay, which was government organized by the government, and you went and you set up a stall, you set up a unit and showed the design, you will get protection if within 1 year of that exhibition getting over, you apply for registration. Nobody can say that, listen, it was already published in the exhibition, if it was your design only which you had published in the exhibition. Let's read. The Designs Act contains provisions regarding exhibition of designs at the international exhibition. It was stated that exhibiting a design at a government approved exhibition, so government approved exhibition was there, cannot constitute as a barrier for official registration of that design if in that government approved exhibition I had exhibited that design. So I had only exhibited in that government approved design, and now moment the exhibition is over, within 1 year I apply for registration. It cannot be said that it was published earlier. I will say it was my design only, provided, now this is most important, not 1 year, sorry, take the correction, that provided that the applicant submits the application within 6 months, not 1 year, within 6 months of conclusion of that exhibition. Very simple. Under this provision, the exhibition of designs or article to which a design is applied okay, so whether it was published by me or under my name or my agent or anyone illegally publishing that design in or my design, so I can still get it in my name. So conditions that they've given to fulfill to get protection, that the exhibitor exhibiting the design gives the controller previous notice in the prescribed form, and the application for registration is made within 6 months from the date of first exhibiting the design. Now two things, before the exhibition you have to do something, before and after. See, before means what? What are they giving? Previous notice has to be given to the controller that listen, this is a government recognized exhibition. I will be producing certain original designs. This is the design. Moment it gets over, I will register it within 6 months and we register within 6 months. So before this he has to give a notice before the exhibition, and after within 6 months he have to apply for registration. Clear? Then that design will be put in his name. Now question is of appeal. If you are unhappy with the decision of controller, you have a right to go to the High Court within 3 months. Okay, under any order passed for section 5 for refusing the design, cancelling the petition, rectifying the petition, under section 35 grounds of immorality, anything you can apply within 3 months. 3 months from when? From taking a copy of the order appealed against shall be excluded. Now see, 3 months from the date on which the order was of the controller was got. Now this is interesting, they can ask you a question. I mean, as a law only you should know that within 3 months you have to go in appeal. Right? Now imagine the order was passed today, but the order copy was given to me after let's say 2 days. So that 2 days time period will be excluded, because getting the copy, because I can file an appeal only if I get the copy, the physical copy with the stamp of the court. So in calculating the said period of 3 months, the time taken in granting a copy of the order appealed against shall be excluded. So if they had taken 5 days to give me the order copy, that 5 days will be excluded. After that 3 months will be counted. Okay, and the High Court's order shall be final after they will consult with all experts. Okay, and that is it. We've covered the entire chapter, okay, in detail, and all the exam questions also will come from here only. So that is it. Thank you so much. Clear? Have you understood till here? So I'm done with the chapter. Another chapter has been knocked off. Okay, for you all, the entire chapter has been knocked off completely from the module. All you need to do is complete this entire chapter, studying it as well. Have you understood till here? Yes or no? And don't forget to inform your friends also. I do take up the lecture. It takes normally, since this is a new syllabus, there are these new chapters which are there, and it takes a lot of efforts to make these notes. So that is why it takes a little bit delay in the time to take these lectures. But I can assure you, once I start the lecture, I complete the lecture within 1.5 hours in full detail. Okay, Mohammed, hello, good evening. Good evening, Yeshu, Sona, thank you so much. I will see you all again tomorrow. I will put up which topic I will be taking. Okay, so that is it for today. I will see you all again tomorrow. Take care guys, bye.